thanks to the Taxmann publication to invite me to deliver this lecture on the new uh, law which is just enacted by the competent legislature, that is the Parliament of India, according to the constitutional provisions, and will be implemented from the 1st July 2024. And these three laws are the major laws in the area of criminal law, and whereas the law of evidence is related to the civil as well as the criminal matters. But so far the procedure is concerned, it is very essential to know about the Bharatiya Nagarik Suraksha Sanhita. And it is a law which have the provisions for the comprehensive procedural system of criminal administration of justice. That's why there are a major amendment, I can say the major portions of the new law and the some minor amendment in the existing provisions of the section, though the serial number of the sections has been already changed. Therefore, the category of the new law can be divided into two categories. Number one is major changes and another is minor changes. And so far, the detailed analysis of the Bharatiya Nagarik Suraksha Sanhita, it requires to make some points so that we can very easily try to understand what is the new law for the speedy trial and protection of human rights as well as for the citizen-centric. Therefore, the point is that overview of this Bharatiya Nagarik Suraksha Sanhita. First is the statement of the objects and the reason why this Bharatiya Nagarik Suraksha Sanhita enacted by the appropriate legislature, that is the parliament. Second point is related to the what is the recommendation, what are the recommendations of the parliamentary standing committee. And third is the relating to the speech of Honorable Home Minister in the floor of the House of Parliament. And another is relating to the reference which is given in this BNSS about the other law also. And then what are the fundamental changes in criminal administration of justice by enforcing this unique law in India? Another aspect which requires to be discussed, that practical procedure approach of new law, and what will be the practical approach, and how far this law will change the existing practice in the code of law, and application of BNSS in progressive India. Why this law was enacted, whereas there was the existing law of 1973 after the independence. So what is the new points on this law? And then another is system of electronic courts in India, because if you will see the before the last section, that is the 1530, which says about the electronic courts. And then use of technology in the criminal administration delivery system, recording of everything, even if the proceeding of the court, witnesses of the case, and the property, even if the statement in the court or outside the court, that is the in police station. Then another point is that challenges and solution for the implementation of the BNSS. There are some challenges because in every law, if we will analyze as a researcher, there are some points which can be discussed in a critical manner. Therefore, there are some challenges, and how these challenges can be solved in due course of time after the implementation of this law. Then another point which requires to be delivered before the audience, that is the human rights approach of the BNSS, because the procedure which is applicable in not in the BNS, Bharatiya Nagarik Sanhita, but in other laws requires to be adopted the human rights approach. Then another very essential point is speedy trial under the BNSS. What are the provision? How we can say that there will be the speedy trial, and what limit has imposed by the legislature for the trial and for recording the statement and for the adjournment. So many things are there. Therefore, the I can say this is a law which will strengthen the speedy trial system in criminal administration of justice in India. Then, of course, if we will see the statement of our founding fathers, the one of the member PK said, he said that the purpose of the criminal administration of justice is that we cannot be true ourselves if we are not true to others. We cannot be free individually unless every individual regards and respect the freedom of his neighbors. This is the statement of one of the member of Constituent Assembly. With the object of this statement, it will be proper to say that the procedure which is framed by or which is enacted by, made by the parliament is for the cooperation, coexisting, and love to each other in India. And the same was said, if we will see the another direction, the another direction which says that why a accused is in prison, because the procedure says that the fair trial should be there, the speedy trial should be there, the opportunity of hearing should also be given. Even if all these provisions are there, the most of the under trials are in prison. What is the reason? And about this reason, one of the very famous political leader of the USA, United States of America, as a president in that time, said that a person is not a prison because he is guilty, and he is not a prison because he has been punished. He is not a prison because there was the apprehension that he would escape from the custody. But the only reason why he is in prison is that he is poor. So that's why the legal aid provision, whether these provisions are incorporated in the BNSS or whether a person have no resources of economy, can be capital, can be imprisonment or can be given the imprisonment to him. So these are the questions and the challenges according to the philosophical aspect of criminal administration of the justice. Then it is a very short span of time. Therefore, there are the various provisions which are under the BNSS. These are the in the CRPC, the statement which was given at the time of the debate of the framing and enacting this law in the parliament said that the CRPC was from FIR, complaint, final order, and appeal. All the provisions were there in the under the CRPC. But however, the purpose of BNSS is a good governance. And the meaning of the good governance is speedy trial and hearing to all and provide the justice to the person, and the citizen-centric should also be there. Then the efficient justice system should also be there. This is the one of the very essential quality of the good governance, and the basic purpose of this law is to strengthen the good governance in India by providing all these facilities. Then another essential point relating to the good governance is citizen-centric new criminal procedure. It should be there. And how one can say that the citizen-centric? If a criminal has committed any crime, and that should not be escaped from the provisions of law. And another side, the innocent person should not be convicted by the court. Therefore, the balance of convenience should also be there, which is called the protection of citizen as well as the criminal who has committed the crime to go behind the bar also. And therefore, there are the provisions, and we will see all these provisions to repeal and modify 7 decades old criminal procedure. Okay, and a new need of the contemporary and aspiration of the people according to the aspiration, because in 1973 when CRPC enacted, and it was earlier 1898 also, then there were some lacuna, and in between 73 and 2023 or 2024, there are lot of changes relating to the technology, relating to the transparency, relating to the protection of human rights, and pertaining to the legitimate expectation of the citizen. Therefore, the Sabka Saath, Sabka Vikas, Sabka Vishwas, and Sabka Priyas, this shows the speedy trial and the demand of the people, problem in the society, and development of the society, technology, literacy rate, and the method of committing the crime. There was the issue. Therefore, this BNSS enacted by our popular government for the smooth running of the country and for the welfare of the society. That's why this is the object of this law. And another, if you will see the provisions for the investigation also, and to take the help of the forensic science expert, there is a provision. Though there is a time limit is also given to state will frame the rules within 5 years, and unless there will not be the laboratory in a particular state, the help shall be taken from the another state also. So many provisions are there. But the main point is that the forensic science expert help shall be taken by the investigation officer or police administration at the time of investigation. This is the point. Use of electronic communication. Most important aspect of this BNSS is that in most of the chapters, except the 5 chapters, there are 39 chapters, and there are the lot of sections, including the 531 also, and repealing is a separate chapter. As the last chapter, there are mostly in every section there is a provision for the electronic use from beginning to last. Beginning means at the time of the committing the crime, and scene of crime shall be recorded also, and then after investigation, arresting, and then lodging, all these things first to last, there is a provision for the use of electronic communication. This is the most fundamental core change in BNSS, and it means in future in India every court shall be a electronic court, and a specific time limit for every procedure. Even if for the judgment the time limit is given there, for the adjournment the lifetime limit is given there, for the providing the judgment of the copy there is the time limit for that, and for delivering the judgment also after the over of the argument there is a time limit for that. So thus specific time limit for the strengthening the speedy trial is also given here. That's why in the summary or in the main point we can say that citizen centric in the real sense is their BNSS. Then use of digital means also, and preferably it is written in the section where there is a provision to record the statement, scene of crime, and the proceeding, property, and so on. It is written that preferably use of cell phone, not the computer, because in the side it is not possible to carry all the items of the electronic communication, and then there will be the problem relating to the internet. But in cell phone, in the every area or every place, there will be the availability of internet. That's why it is written in section itself. Then in the cases where punishment is 7 years and above for withdrawing the cases, this was one of the issue from very beginning. It might be nullity case and other cases, the withdrawing the cases. Now it is given, it is written in the, if the central government or state government, as the case may be, will withdraw the case, then at that time, there will be very essential to give the hearing to the victim also. Victim means family members and so on, because it is a responsibility of the state, and a criminal case is one side the state and another side the accused, but vice versa, there are the exception in complaint cases, all these things are here. Then summary trial is very mandatory in PT cases. PT cases, summary trial will be there, and no option is given to anyone, and summary trial shall be conducted by the magistrate also, and then this will be the final, and the property stolen in case the amount is increased 20,000 amount related to the property which has stolen, that will come within the summary trial also. Accused person may be examined through the electronic means. If a accused is in prison, if a accused is in another place, if accused is not being brought in the police station, then for that purpose, for recording his statement, the electronic means shall be used according to the BNSS. Magisterial system has been streamlined in this system also, and thus the, after the long debate in the parliament and the report of the standing committee, finally it has been enacted, as we are well aware that the 25th December 2023 also. Then it has been also notified for its implementation from the 1st July 2024. This is the object. Then you can see the report of the BNS and the standing committee, what was there, and some, as I have raised some points. First of all, some major changes and some minor changes. And major changes are related to the incorporating new sections. And minor changes are either to substitute the word, or to include or to increase particular subclause, or to repeal the word or the subclause. These are the minor changes. Therefore, the major changes in the BNSS, if you will see, there are new sections. I'm just quoting not the CRPC section, but the section which is written under the BNSS. If you will see, 86 is there, 105 is there, 107 is there. These are the total new provisions. 172 of BNNS is there. 336 is the new provision. 356 is the new provision. And 398 is the new provision, which is related to the witness protection scheme. And this is the new. And say 472 is the new provision relating to the pardon power of the Honorable President of India and the Governor, as the case may be. Then you can see the another point which is very relating to the 530. 530 is one of the another point which says about the provisions of the communication system through the issue means recording the statement, all these things shall be used by the courts also. These are the major amendment in the BNSS. Because then minor, if we will see the from very beginning, that is the section 2, which is relates to the, it is a big portion of enacted law rather than the BNS. BNS, the section reduced and the chapter reduced. Earlier there was 23, now 20. And here it was the chapter is 39, it was it was the 37, and the sections there were 485, and now there are the section 531, and so many sections, so many provisions, so many exceptions, so many provisos are incorporated and some has deleted because of this good governance goal and object of our popular government. Then I'm talking about the definition clause. If you will see, there was no provision earlier about the bail bond, and audiovisual, and relating to the communication, electronic use, and one new clause inserted or incorporated under section 2 clause 2, because that was the provision in the CRPC also. If any definition will not be given in the section 2, the definition is given by IPC. I'm talking about CRPC. That definition given in the under the IPC shall apply, and the same half portion is the provision is given here also for the purpose of definition under section 2 subclause 2. But the remaining means the apart from this provision of IPC and so on, here BNS, the another is, if any definition is required to be applied which is not given under section 2, the IT Act shall will apply. There is a provision. It means the CRPC, the center point of this BNSS is the use of information technology. Just like the use of the BNS, because BNS is substantive law and BNSS is a procedural. That's why the equal status is given to the IT as well as the BNSS. Of course, the BNSS is applicable in special laws also. It is applied in special law. BNS has the limited scope, but the BNSS has the wider scope. And BNS have the one area of criminal offenses, but the procedure is applicable in special laws. If there is no provision, so that's why section 2, it is amended. And if you will give the attention from the chapter 2 also, and there are the various provisions, and under section 15 of the BNSS, there is the police officer can be appointed as the special executive magistrate also, police officer, but the rank is also there. This is the new provision. This is the new provision here. Special executive magistrate under section 15 of BNSS shall be appointed by adopting the procedure which is written there by the competent authority to the police officer. So, then another aspect under this also, the constitution of the courts under chapter 2 also under chapter 2, that there is a public prosecutors, and public prosecutors category has been changed. Earlier there was a director, there was a deputy director, and here for Delhi Special Police Act there is another provision is there, and the assistant public the director post is also created, and they will their work is also divided. What the director public prosecutor will do, deputy director public prosecutor director will do, and the assistant director of the public prosecutor will do, and how they will monitor the cases relating to the nature of offense. The meaning is thereby that the year of the punishment, their duty is also basically was given in this provision also. Very important aspect which is being discussed in the social media or is being discussed in the in between the legal luminaries or the practitioner lawyers relating to that is the community service. Community service punishment is the subject matter of BNS, Bharatiya Nagarik Sanhita. But the procedure and who is competent to give the community service punishment to the convicted accused, this is the subject matter of the BNSS. Therefore, if you will see the section 23, which is related to the power of the magistrate, not power of the session judge. It means there is a category of the magistrate, first class magistrate and the second class magistrate. And this power of the awarding the punishment relating to the community service is provided under section 23 of the BNS to the first class magistrate and the second class magistrate. But the point is that what will be the duration of the community service and what kind of the punishment shall be given. There is no categorical explanation. Explanation is there. One explanation is written under section 23 that it will be without remuneration in the social interest, depends on the magistrate. Therefore, point is that the community service which is existing in the other countries and which has already been given the punishment by Indian courts also earlier is the part of the enacted law, that is the BNSS. But whenever the punishment shall be given by the magistrate in future, the category and the work, days, hours shall also be clarified by the court. And there is a scope of framing the rules, although this is not written under section 23, because rules cannot be framed by the executive as a delegated legislation unless it has not been permitted by the Parent Act. That is also the matter. Then income passage of social restitution also, because under the social restitution, the everyone is no doubt the responsible for the betterment of the society. At the same time also, the convicted person who has completed the punishment is also the part of society. Therefore, rehabilitation, restitution, and to become the ideal citizen of the person who has convicted. So many issues are there, and the answer was given under the BNSS. The 33 public give information of certain offences, mostly related to search and seizure of the property. Meaning is thereby the information will be given to the magistrate. Information will be displayed in the online of the police station, and the information will also be given by using the social media to the public also. And one another very interesting, there were the lot of cases decided by the court in this regard relating to the handcuffing in serious cases of arresting not in economic offenses. And these are the cases which are very, very essential to be discussed here, that in which cases the court will give the authority to the police, or the police will have the power according to the provisions of the basically relating to this handcuffing to the accused. And these cases are very serious nature cases, because there is one side the question of liberty, question of freedom, and another, and there is a common law principle, even if the no person can be said the guilty unless his guilt has been proved. There is this issue. Therefore, to restrain the accused so that he cannot escape and she cannot escape from the lawful custody of the person, and thus the handcuffing can be used in the serious cases. These are the cases which says that at the time of arresting, relating to the rape and relating to the offense under the POCSO and relating to the matter of acid attack. And if it is necessary to use the handcuffing, it can be used, and this is permissible under the BNSS for the arresting to the accused person because the accused person should not be escaped. This is the purpose. But one thing is very relevant, that the handcuffing cannot be used in economic offense. In economic offenses, though the economic offenses, nature of the economic offenses may be different, but the handcuffing shall not be used in it. And 52 of BNSS, examination of person accused of rape by medical practitioner without any delay. And there is the provision for that purpose. The time limit has been prescribed. Without no delay, without any delay, the time immediately, within 24 hours, the medical examination should also be conducted. In view of the repeal of the sedition, one of the most important aspects which is being discussed earlier also, and the court has decided this matter, and the suspended the use of the sedition, which was enacted during the British period. There is no scope in the BNSS also for the sedition as a that BNSS as a procedure or as a offense under the BNS. But one thing is also there, that the provision relating to the taking the security and security bond by the executive magistrate, if there is the apprehension of breach of the peace, then that can be taken by the magistrate for the good behavior. And that's why section 127 of gives the power to the executive magistrate for taking security from the any person based on sufficient ground for proceeding also. Sufficient ground should also be there. Time bound release of person 172 by the police within 24 hours in case of persons to bound to confirm the lawful direction of the police. This is also the new provision. It says that under the 72, if any person will not follow the lawful direction and order of the police administration, then police can arrest to that person. And in the arresting at that time, you might be seen that if the person, accused person, will give the false information or will say the will give the false name and so on and address, the police have the power. But here, if any lawful order has passed by any police officer and that is required to be followed by the all citizens whenever it is given, the word is lawful order. Meaning is thereby that according to the provision of law. That, and if the persons will disobey the order of the police, lawful order of the police, then police can immediately arrest that person. And the arresting period will be of 24 hours. And within 24 hours, the police administration can produce that person before the magistrate, or if it is a petty offense, then the police officer can release to him. And that is the very interesting human right approach in lodging FIR under 173 relating to protect the disabled person and women of rape victim also. And there was some protection earlier also. The FIR shall be lodged by the female and so on. But here something is new. That is procedure for the preliminary. That is the new. What is the new? Just like this provision relating to this earlier, the 160 of CRPC, you can see that the recording of the statement of the witnesses. Here also, the provision says that under section 179 of the BNSS, that if a person have the age above the 60, this is new provision, age and the person is mentally and physically disabled, person have acute illness, the grounds are there, above 60 years, illness, mentally, physically and disabled, then the person's statement, if it requires, shall be recorded at the residence of the person, not in another. If the person whose statement requires to be recorded is interested to go to the police station, okay. And if he is no capacity, then his or her statement shall be recorded at the residence of these persons also. Therefore, the one another aspect is which says that clause 2 of section 173 for providing copy of FIR, because there was a recommendation of the standing committee also, and there is a practical problem. The copy only the person who has given the information to the police for registering the FIR. There is a provision, or that was the provision under CRPC also, uh, shall be given to the free of cost to the person who has given the information. Here, one thing is included, one thing is in addition. The information is entitled to get the copy, number one, okay. Number two, the victim is also entitled to get the copy of the FIR. But the accused about the accused, the victim means the information was given by A, and victim may be B and C, and so he may be or she may be disabled, he may be C, and he and C may be the minor, and so many things are there, but they are the victim. Meaning is thereby that the person who has given the information is entitled to get the FIR copy and the victim, but there is no provision for the accused even if. And there is a case of the Supreme Court, Youth Bar Association versus Union of India. In that case, the Supreme Court said that copy of the FIR should also be okay when the proceeding will start and charges shall be framed and the accused shall be presented before the court. There are the provisions. The accused can get the copy. There are the various documents shall be given under CRPC. It was there also, and some other new addition is also on the BNSS in the electronic form. So this is the again the matter of challenge. Power of investigation under 175 to DYSP as per the gravity of the case. This is the new 175. The power gravity of the case, if serious cases are there, the investigation shall not be conducted only by the IO, investigation officer, not less than the rank of sub-inspector. The extra power is earlier in some cases like the atrocities against the SC/ST Act or some other acts, there was a provision for that. And here also the in gravity cases, means the cases which are very serious, the power was given to the DYSP for investigation. Then of course, as I have said, that the persons who are not competent to go to the court because of the mental illness and the physical illness, and it can be said that it is in the interest and protection of the human rights of the senior citizen and disabled person and the female and so on. Though finally, there is no hesitation to say that this provision is in the interest of the justice for the protection of human rights of the group who are physically and mentally not capable to face the police. I will not use the word, but the police action. That's why this special kind of facility was given to them. And then, of course, the 23 you have already seen, and 83, 86 identification and attachment of property of proclaimed the person. There are two provisions under the BNSS, very relevant provision relating to the siege of the property and to forfeit the property. One is proclaimed the property of the proclaimed offender. Another, if any property is involved in the crime, for example, the corruption, for example, the income without the reasonable sources or legal sources, So many things are there. In B, under the BNSS, there are the provision that in such situation, after adopting the procedure, because the property is the part of the inherent right of human being. Therefore, procedure is also there. Notice and then all is then give to the opportunity of hearing that it can be seized, it can be forfeited. Therefore, the provision chapter 7, 111 to 124 relating to attachment, forfeiture of the property shall apply in such cases. Cases means the proclaimed offender's property and the property which is earned by illegal means. Meaning is thereby that involved in crime. Second part is involved in the crime, and that is the matter. And then if we will see the 105 recording of search and seizure through the audio, video, electronic means also for the purpose of transparency, for the purpose of preserving the record for future, for the purpose of appeal, for the purpose of the showing the fear action at the time of taking the taking the serious action against the accused, it should be recorded, electronically recorded. Any property, article, things under the chapter such and such, searched by the police officer under 8185 shall also be recorded. Recorded means recorded by electronic means. These words written under 185 clause 2 proviso related to the recording. Very essential aspect. Recorded preferably by the mobile telephone. Because at that time, there will be very easy to keep the mobile telephone. And the mobile word is used in the BNSS. This is also the relevant aspect. Then I have said that by order of the courts, the restoration, the property can be released also. And during the investigation by police officer found any property related to crime, as I have said, they may make an application with approval of SP or police commissioner. The meaning is thereby that the power is given to the superintending office for the attachment of the, for the forfeiture of the property. But there is one rider, and that rider is, you will see, that rider, the application SP police commissioner and the authorized code also for the attachment of property, and order shall be based on the reason to be believed before and after receiving the evidence that this property is involved in the crime. Meaning is there, the rider says that the fair procedure says that there should be the evidence for that, and that should be recorded. And only then one can reach in conclusion that the property is involved in committing of the crime. And for that purpose, for the attachment of the property, a notice shall be given to the accused also. It can be issued to any other person if accused is not available, but property, it may be movable, it may be immovable property, and the property will remain in that place. If it is immovable property, it will remain in bank or it will remain in X place. Every property cannot be carried by the accused after committing the crime. So there is a provision. The another person where there is where the property is in possession of that person. In case of the material facts available, court of magistrate may pass an order for attachment. SP application will be made to the SP and police commissioner, then court will give the final. If the person shall not present, court may 14 days notice is there. It is essential to attach the property, then ex parte shall be given. Very interesting point is that there was earlier the provision relating to the restoration of this and all these ex parte decision, and there was the 130 days and in that the same code also. But here is different kind of provision. It says that in case of emergency, court or magistrate may pass an order, but information to the DM of the attachment of that property which have the relation to the crime. Then what the DMs will do? The district magistrate within 60 days shall proceed of the crime, and he will also take the precaution. Precaution means relating to the observe and follow the further procedure. And that further what is that for further procedure? That if no claimant is there, the property shall be forfeited by the government. Again, the district magistrate will give the opportunity, will issue the notice within the 60 days in case of the ex parte decision given by the court magistrate in the for the attachment of the property. The another the system of the fair play in action and fair procedure is vested on the power of the district magistrate. Total 8 clauses are under 107 because I have said that property right is one of the human right. Therefore, the litigation will increase because for the protection of the human right, much scope for the various stages as it is given. Jiladhikari, district magistrate is empowered for the second stage. Then litigations will also be there. And that is the one another challenge about it. Then interestingly, restoration of ex parte decision is not in such form because the power of second hearing is given to the district magistrate. The same court cannot do anything. Magistrate court cannot do anything who has passed the order of the attachment of the property which has the relationship to the crime. Has no power after giving the order. Then now you have seen that there was the 160 and here 172, that power given to police and so many things about it. But one problem has one provision has been removed from the CRPC in the form the BNSS, that is Section 153 of CRPC, which was related to the inspection of weights and measures by the police officer of the any shop. But there is no provision under this BNSS. It has repealed. It means there is a special law and there are the special authorities and they will do this work and they will visit in the shops and the place where there is a measurement instruments, and this has been revealed from here. A new section related to strength and power of the police already given so many things. But interestingly, if any person shall not follow the order of A, that I have already discussed, all are bound to fulfill the order, then there is no problem about it. Evidence of public servant, this is most important. This is the new, and there was a delay. And the provision which I am going to discuss, this is related to the speedy justice. That is the section 336 of the BNSS, where it is a provision that this is a chapter 25, where any document prepared by the public servant, by the scientific expert, or by the medical officer. There are 3 terms: public servant, scientific expert, medical officers, required to use as a evidence in any stage, but they are not available. And the case takes much time during the trial, and there is a need of the witnesses at the stage of trial. Then, in absence of these persons, it affects the justice delivery system. Therefore, there is a new provision that in case they have transferred, in case they have retired, in case they have died, or in case, the fourth point is, cannot be found or unable for deposition for the recording statement, they are unable because of the old age, because of the another reason. because of the sickness, illness, so many things are there. Then to avoid the cause of delay, court shall secure the presence of the successor. Successor means whom? Successor means the successor of public servant, successor of the scientific expert, successor of the medical officer. You might be thinking that the sir medical expert, the X was conducted the postmortem, and now he has been died. The how the another person was can said or can record the statement that what he found at that time, and there will be the document prepared by earlier medical officer. And if there will be any dispute relating to the expert opinion in the court, dispute means any party raised the issue, only then the expert can be called for recording the statement, for the cross-examination, for the analysis of the genuine report prepared by the earlier medical officer. The meaning is thereby that, as I have said, that you may be thinking, you are thinking that how the another doctor will give the statement. That the answer I am giving here, that it is related to the document. Number two, it is related to the medical expertise system of medical science. Medical expertise system of medical science means that the medical science, what it says, that statement shall be recorded. Cause of death, it is written. That's why this is the totally new problem. That successor will present in the court, and to avoid the delay, and a statement may be recorded through audio, video, electronic means. Suppose he has no time, she has no time, they are busy. Now you can say, sir, if this recording of the audio, video facility was there, why the successor is coming for recording, or coming forward for recording the statement? Why the earlier is not coming? No, because these are related to the statement of the person who has performed the duty being a public servant under the color of the office. I can say under the color of the office. Therefore, the relevancy of the statement, it might be challenged in future, but so far my understanding is concerned, it is prepared under the color of the office during the office hours and in capacity of a officer of public servant. Therefore, the successor, because there is a perpetual character and person comes and goes, there is a common seal, and every record is available. Expertise which the X have earlier, the same expertise or better expertise have in the capacity of the successor also. Therefore, this is also very interesting point relating to this aspect. Then see, inquiry, trial, or judgment in absence of the proclaimed offender. This is also the one can say, sir, it is against the fair principles of criminal administration of justice. The answer is no. Because of the delay, number one, and because of the proclaimed offenders are not available, and then in absence of the proclaimed offender, to avoid the delay, there is a new section 356 under the BNSS. This section, because the time constraint is also there, and you can go through this, and there are conditions: issue 2 consecutive warrant within interval of 30 days, first off. And even if after issuing the warrant, it may be non-bailable, and he and she is not coming before the court, and publication in 2 newspapers also. And that should be the national as well as the local of that area. Inform his relative or her relative and friend about the commencement of the trial. The fair play in this way is also there. And even if he is not coming before the court for the defending himself or recording statement, whatever is required, then affix information to residence, home, street, notice board. But in absence of the proclaimed offender, the advocate help shall also be given. And suppose he is not in position to hire the advocate or to engage the, rather than the hire, to engage the advocate, then government will provide that earlier, which is called the amicus curiae, whatever is there, witness will examine. And proclaimed offender appears in between the proceedings. Suppose what will happen? Whether from the first date another proceeding will start, the answer is no. Before the judgment he comes before the court, then court will allow him to examine the witnesses where his statement recorded in absence of accused. This chance will be given to the person who will present after the some time in the court. The statement as far as possible by audio visual, and every recording will be there, and he can watch, he can see, and then he can or she can examine to the witnesses. Record shall be kept in order of the court. All these things are though, when that there will not be scope for that, no appeal of this case in such cases, unless proclaimed on these grounds, on another grounds which is not written under this section, that there is a scope under section 356, there is a scope, but law says that what is written in the criminal administration of justice, that will apply. So therefore, for that the linger on to the and to adopt the tactics of the delay in the criminal matters, there will not be the appeal of the violation of procedure which is written, that is the law. Unless proclaimed offender appeared, time limit for the appeal is 3 years, of course. Appeal is a right. The state can apply this provision on the proclaimed offenders. All these things is also there. And this is also the new, the witness protection scheme. And but interestingly, if you will see under 398, there is again the debate about it. The every state shall prepare and notify. Meaning is thereby, as you know, or we are competent to know, that this is the subject matter of concurrent list. Entry number 2. And therefore, there is a power of the state government also. And witness, there is a dangerous for the recording the statement. Witness protection scheme is in the first time incorporated under the procedural law for the criminal administration of justice, that the state shall frame the rule. Meaning is thereby that there are the states 28, 29 and so on. The rules may be the different in the different states, and these rules shall be notified. And the law will come into force from the 1st July. And when the rules shall be made, so many questions are there. A witness protection scheme for the state with a view to ensure protection of witness. And it is in Canada, European countries, which is already existing, or in India, there is a witness protection scheme already prepared in the year 2018 in India, not in CRPC, but it is a separate matter. This is very important. I will finish this one, and then there is the time is giving the alarm, and that's why I will stop this issue or this deliberation. And if there will be the relevant question, one can ask, and I will try my level best to give the proper legal answer. Then this is the new. And this is, what is this? You can watch mercy petition in death sentence cases, section 472. This is totally new. There is a question that it is a provision under the Constitution. 161 and 72. And governor and the president of India. But why this is insulted? or this is incorporated as a new provision under the BNSS. Under the Constitution, one thing, it is not written here. It was not the debate, it has not debated, and it was not given in the statement and the object. But think over it. Under the Constitution, there is no procedure. After the petition, then review. After the review, then petition, then mercy. So many things are there. Under 472, if you will see that the procedure has been left. This is available only the convicted accused of death penalty. Number one. Locus standi to the convicted person to legal hearers or any other relation. This is the local standi given. And may file the mercy petition before the President of this is the constitutional provision 72(161) within a period of 30 days. Within a period of 30 days is a procedure when 30 days will count from the date when the superintendent of jail inform him or her about the dismissal of SLP, appeal and review. 30 days shall be counted from that day. It means it is a last remedy. Inform about the confirmation of death by the High Court in case of the governor and in between. Then mercy petition firstly to go to the governor. It was earlier also court. Then to President of India within 60 days after the rejection by the governor of the particular state. 60 days. 30 days, then 60 days. Every convicted for death of right to life mercy within 60 days after receiving information. And procedure says that after receiving the mercy petition by the President of India, so the central government will seek the information from the state also. So then 30, 60 and convicted death right of life of mercy within the 60 days after receiving information that relating to the mercy petition is rejected by the government. So many provisions are there as a procedure, not as a constitutional provision. Constitutional is second part, and this is, and it may be challenged. It may be challenged because there is a depth study procedure, and the why this Bharatiya Nagarik Suraksha Sanhita is in Hindi name, it has also been challenged. And it was the issue before the standing committee also. Finally, the court and the standing committee said that the text is available in English. The name may be in Hindi or maybe in English. It is not violation of 348 of the Indian Constitution, article of the 348 of the Indian Constitution. That's why I am leaving this issue. And if please, there is a representative of the that Taxmann publication, and if there is any query, you can ask. She will communicate me because the chat box is not visible here. If any query, any question, any issue, hello. Nobody is present because she has given me the instruction that hello.
So there are no questions in the Q&A box yet.
Okay, if there is no question, then thanks to the publishers, especially Mitra Saab, Gurwal Saab, and the organizing this Ms. Sharma, and the persons who are involved in this organizing this webinar. Thanks to all and participants also.